Okay, I will continue on then. Based on that information.
Oh, she's having a meltdown.
Mr. Quadron, let's not comment on that. There maybe are issues that we're unaware of.
Before we even step into this courtroom, let me set the stage for what you're about to witness, because this one spirals fast. We've got a homeowner who has a reputation for suing just about everyone in her orbit. And today, she's taking on a contractor over a 9x10 kitchen remodel that she claims went completely sideways. But here's the twist. This isn't just about cabinets and countertops. This case starts unraveling into questions about licensing, service of process, alleged avoidance, YouTube streaming drama, and even accusations about court monetization. And trust me, the tension between these two? Immediate. You'll see procedural confusion, subtle power plays, and a judge who is clearly trying to maintain order while both sides test her patience in very different ways. The plaintiff insists she's been wronged. The defendant claims he's being chased down unfairly. And somewhere in between? A $6,000 dispute that feels like it's about a lot more than money. This is part 1, and if this is the calm version, just wait until the sequel. So buckle up. Grab your popcorn. Because what starts as a small claims kitchen remodel case quickly turns into courtroom chaos.
All right, we're here in 24S000235. We have the plaintiff, Jenny Kiriconi, present. We have the defendant, Justin Quadron, present. Sir, do you own Affordable Land Care, LLC?
Yes, ma'am.
All right, he is the owner of the other named defendant, Affordable Land Care, LLC. So I see that there has been an amended claim filed in this matter. Let me go ahead and make sure that all the parties are aware of this new amended value. Have you received that, sir, the amended claim?
I haven't received any paperwork, no.
Well, how do you know to be here today, sir?
Well, I received paperwork previously, like months ago, or weeks ago. I'm sorry, I'm busy, so I lose track of time. But I haven't received paperwork for this court date today. I called you guys at the district court and followed up I looked up the dates, and I was just following the trail, but I haven't been served proper paperwork yet. No.
Well, I have right here, and I just want to make sure that everything is correct. I have right here that a proof of service. It says here that you were personally served on February 2nd, 2025 at 1:30 p.m. and that you were served.
And that was on a Sunday?
Yeah, I'm not quite sure.
That's the one I was served, but there were no court dates on that paperwork. It didn't say, hey, you're at this date, and it didn't say what. There was no exhibits. There was nothing attached to that. I didn't know what I was being sued for other than what was on that paper.
1 second. Ms. Kiriconi, did you file proof of service on the amended claim?
I attempted to, Your Honor. And in fact, yesterday I delivered to the court proof that I engaged Emerald Legal Service down in Eugene, and they attempted many times to serve Mr. Quadron, and that he refused to open his door on many occasions. There is something that they call a proof of due diligence as well, along with the other document.
Right out of the gate, we're getting emotional instability vibes. And that matters. Because in small claims court, credibility is everything. Judges are watching body language, tone, consistency, not just the paperwork. When someone appears overwhelmed or reactive before the substance of the case even begins, it subtly shapes perception. Now, to be fair, court is stressful. Anyone would be nervous. But when someone has a pattern of litigation, as hinted here, that emotional volatility starts to carry more weight. And here's something important. The judge immediately shuts down commentary about her behavior. That's professionalism. The court will not entertain character attacks. But make no mistake, even if it's not spoken out loud, demeanor absolutely influences how testimony is received.
All right, so service can only be by mail, by personal service, or by substitute service. So if they have been attempting to do it, then you would need to just serve him by certified mail, because at this point, we don't actually have proof of service of the amended claim. I will agree, I do accept. All right, but that hasn't been filed, ma'am. I don't have a proof of service on my end. I see that you have that form, but I have a defendant here saying that he didn't receive the amended claim.
He did not receive the amended claim, Your Honor, because he has refused to open the door to the personal service representatives trying to serve the amended claims notice.
And I hear you, ma'am, but unfortunately, he does need to get that serviced. So you can do that by certified mail, and that would be sufficient. He doesn't need to be served by an individual then.
When I have done that before, he refused it. He refused it to pick it up for over 30 days. That's why I used a service to inform him of the February 2nd one.
Well, it can be left in a mailbox too.
I will attempt again, Your Honor.
Okay, all right. So, sir, you are here. You followed the trail of dates. You are now aware that you are going to be served an amended claim.
What address is she mailing them to? Because I have moved. I'm a single dad and I had to relocate to be near my kid.
Sure,
So she
Ms.
might be mailing
Piraconi.
them to the wrong address.
What's the address that you're trying to serve, please? Ms.
It should be on the paperwork from the service, Your Honor. I do not have that paperwork right in front of me.
I don't have a proof of service for the amended claim. For the small claim, it is.
Yes, you do not have proof of service for the amended claim because the defendant has refused to open the door to Emerald Legal Service of Eugene.
Ma'am, I understood.
Okay.
And
Okay.
I understand.
And I understand he can also refuse to pick up the registered mail, certified mail. I will attempt to do that again, Your Honor, at his Eugene address.
That is not what I'm asking, ma'am. I'm trying to find the address to tell him. And I said, I don't have one for the new
All
proof
right,
of service. I will look at the old proof of service. And I'm asking you, is that the same address you are trying to serve?
No, Your Honor. That address is open.
Well, Eugene, Oregon.
Eugene, Oregon.
Is that your address, sir?
Yes.
Okay. All right. Well, you're now put on notice that you are trying to be served this amended claim. At this point, there's really no reason for you not to accept service of it because we do have proof of service on the small claim. I don't think there's any difference. So the original claim is asking for $6,000 in reimbursement, and the amended claim is asking for also $6,000. So not an additional, but the same amount.
Okay.
So
what does it say? What are the accusations?
Well, I need you to accept that. It says right here, cost of permit and inspection costs to remediate items, failing inspection, post to complete work left undone, including labor and materials, cost of cleanup. So,
Well,
sir,
can we avoid time and just enter court now? So
No.
we can just.
I don't have time. I have a trial in 5 minutes. So today
Okay,
is
so I still
purely.
have to wait for her to serve me.
Yeah, so she needs to
Okay.
serve you, but we can set up a trial date right now. I just want you to know there's no point in avoiding it because she's already served you on the other one, which I could have trial on
Yeah,
the other claim.
I'm not avoiding anything. I'm a
Okay.
business owner and I'm working and
Okay,
I apologize about the inconvenience, but I don't even stay here half the time. I'm between two states.
okay,
So they're just not catching me when I'm home.
okay, all right, but I just wanted to give you a heads up. It's not like
Yep.
it's a bigger amount. It's just, I think she amended the description.
I also want to argue that the amount that she's asking for is higher than what a legal ability to sue for an LLC in the state of Washington. Based off my research, the highest amount is $5,000.
That's only if she's an LLC. You can sue
Got
a
it.
business up to $10,000, but if you were to sue her, you could only ask her for $5,000.
Now we're getting into the procedural weeds, and this is critical. Before a court can even hear the substance of a case, the defendant must be properly served. No service? No jurisdiction. It doesn't matter how strong your claim is, if you don't follow the rules, the case stalls. The defendant is saying he never received the amended claim. The plaintiff is saying he's dodging service. This is a classic tug-of-war in civil cases. But here's the problem. Alleging avoidance isn't the same as proving service. Courts require documentation. Proof of service must be filed. Without it, the judge's hands are tied. And notice the judge's tone: calm, procedural, firm. She's not taking sides. She's enforcing rules. Litigation isn't about who feels more wronged. It's about who follows process correctly.
All right, good afternoon to both parties. If you could please unmute. Mr. Guadron, if you could please unmute, take off your hat, and just drop the... Mr. Guadron, what is your background, sir?
It's a picture of the kitchen that we did some work on, and since this court case we had with you, I found out that it's being broadcast on YouTube, and over 37,000 people are watching us. So I figured I'd put that up there so we can.
All right, sir. I did see an exhibit you submitted, and I am aware that this is now likely being streamed on YouTube. If you could please take down your background. I don't appreciate me being broadcast in the background in a picture like that. Thank you, sir.
Let me see if I can figure out how to do it while we're working here.
I'll wait until you can figure it out, sir.
Does that work?
That's great. Thank you, sir. All right, so we're here in case 24S235. We have the plaintiff, Jenny Quiriconi, present. We have the defendant, Justin Guadron. Are you the owner of Affordable Land Care, sir?
Yes.
Okay, the owner of Affordable Land Care. So it looks like an amended claim was filed, but as of today, sir, $6,000 is being requested by Ms. Quiriconi against you. Are you aware of that value?
Yes.
All right, sir. So, sir, you keep popping in and out. I don't know if you could just stay in the camera, please.
I'm sorry. I'm at work.
All right. Well, this is a trial. So I apologize that you're at work. You're just going to have to take some time off to handle this matter. All right, sir. So going forward, this is a trial. Ms. Quiriconi is going to go first. She is the plaintiff in this matter. I'm going to let her go first, present the evidence that she has for the $6,000 value she is seeking against you. If she has any witnesses to call, she can call them forward, and then we will listen to her side of the story. When she's done, I'll let you tell your side of the story, sir. I ask that both parties do not address the other, that they only address me. If there are any questions, just to me, let's try to keep this amicable. I don't want this to be a contentious situation now that you have brought to light that most people on YouTube like to watch Ms. Quiriconi's matters. So let's just keep this very amicable, please. When you're done, I'll go ahead and offer my judgment in this matter. Are there any questions in regards to any of this going forward?
Yes, Your Honor, I have questions.
What's your question, Ms. Quiriconi?
This moment is subtle but revealing. The amended claim isn't increasing the dollar amount, it's still $6,000. That suggests the amendment is likely clarifying allegations rather than expanding damages. And that weakens any narrative that this is some escalating financial ambush. But what's interesting is the defendant pivoting into legal research about LLC limits. He's trying to show he understands statutory caps. That can be strategic, demonstrating competence, but it can also backfire if it feels like posturing. Judges tend to appreciate clarity over courtroom lawyering. Both sides here are signaling something. She wants to be seen as thorough. He wants to be seen as informed. The question is, who will come across as credible once evidence starts flowing?
Your Honor, what makes you think, as you stated, that people are watching because of my matters and not because it is your court?
That's true. It might be my court.
Your
Any
Honor,
other questions?
are you aware that because that your court has been monetized on YouTube, that I have been subject to harassment by
It's not monetized. How is there any monetary financial gain from this?
the people who stream your court on their YouTube channels have paid subscribers.
What does that have to do with me, Miss Quiriconi?
I am just stating facts regarding your channel being monetized.
It's not a channel. I'm a government employee sitting in a courtroom. This is not a YouTube channel. This is a Zoom trial.
This is true, Your Honor. And people on YouTube are monetizing your court by paid subscriptions to their channel.
And here's where things get spicy. The defendant changes his Zoom background to a photo of the kitchen at issue and mentions that thousands of people are watching on YouTube. That's not accidental. That's a calculated move. He's signaling awareness of public scrutiny, maybe even trying to frame the narrative visually. But courts are not YouTube studios. Judges control presentation. Exhibits must be submitted formally, not displayed as digital backdrops. The judge immediately shuts it down. Why? Because allowing that would blur the line between evidence and spectacle. This also introduces another layer, the psychological impact of public broadcasting. When litigants know an audience is watching, behavior changes. Sometimes for the better, often for the worse.
I object to Mr. Guadron continuing to have the picture of my kitchen in his background.
All right. Mr. Guadron, please take it down and make just a neutral background. That is an exhibit that has been submitted, and I will go ahead and review it at another time.
Can you see? I just want this exhibit that's in my background is pertaining to the case. Wasn't able to give it to you in the photos. I wanted
Okay,
you
well
to
then
see
please take
this
it down. Please take it down.
because it goes against one of her allegations.
All right, so you're going to have to just testify against to that verbally at that point. Please take it down. Thank you, sir.
And just when we think we're about to start the actual case, we derail into a debate about YouTube monetization. This is fascinating. Instead of focusing on plumbing permits or invoices, the plaintiff shifts toward perceived harassment stemming from public streams. Now, legally speaking, that's irrelevant to the kitchen remodel dispute. The judge is a government employee. Open court proceedings can be observed and recorded within legal bounds. The court itself isn't monetizing anything. Third parties may stream, but that doesn't create liability for the judge. This move feels like a redirection tactic. When someone reframes the conversation toward victimhood outside the immediate dispute, it can signal discomfort with the upcoming evidentiary phase. And the judge? She keeps redirecting back to procedure. Efficient, controlled, professional.
Anything else, Ms. Quiriconi? Because we need to begin.
I understand.
All right. So we're going to go ahead and begin. Please raise your right hand. Do you swear to tell the whole truth during this proceeding?
I do, Your Honor.
Please state your full name and spell your last name for the record.
Jenny Quiriconi, Quiriconi.
Thank you. Please begin with your testimony.
Your Honor, last year, I contracted with Justin Guadron and Affordable Land Care to have my very small 9 by 10 kitchen remodeled. I paid my invoices, and within the exhibits you will find representations of my checks that he accepted in full payment of the first 2 invoices generated by him. There are no details of how much labor might be required in hours. And in fact, I did not ask him at any point for documentation on hours. And that is one of the questions that I have for Mr. Guadron, is if he can supply documentation for the number of hours and the days that he worked.
Quiriconi, I apologize. Mr. Guadron, this is a trial. Please take off your hat. Please do not drink beverages, and please do not eat any food. This is a serious matter, sir. Thank you.
I'm sorry.
Ms. Quiriconi, please continue.
Thank you, Your Honor. Because of the nature of the work, plumbing was required. I have since found out that while Mr. Guadron is a plumbing contractor and a general contractor, he is not a plumber. And from the very beginning, he put himself forward as a plumber. A plumber must have that qualification through Labor and Industries. Mr. Guadron is a plumber trainee, and as a plumber trainee, he is required to have supervision on site for his work. To my knowledge, he never had supervision on site. Within the paperwork is who is supposed to be supervising him. I was unfamiliar with that name until I started looking into his background.
Now we're entering the heart of the dispute, licensing and qualifications. This is serious. If the defendant represented himself as a plumber but was only a trainee without proper supervision, that could potentially undermine the legality of the work performed. In many states, performing regulated trade work without proper licensing or oversight can invalidate contracts or open the door to damages. But here's the key, representation versus assumption. Did he explicitly claim to be a licensed plumber? Or did she infer qualifications? And equally important, did she verify credentials before signing the contract? Courts often consider whether both parties exercised reasonable diligence. This is where documentation will matter. Permits, license numbers, text messages, supervision records. Emotion fades. Paperwork decides.
He also refers to, in one of his own text messages from the very beginning, that he and his partner are coming by. Now, there is some paperwork that says he has a partner named Patrick, but there is no last name, and I never met anyone named Patrick. I never heard their name, nor did I ever hear the name of the person who was supposed to supervise him. I was not on site the entire time that the plumbing work was being done. However, when I was here and plumbing work was being done, there was absolutely no supervision whatsoever. Mr. Guadron claims that there were, according to his document, unexpected circumstances. But his document also says that his labor is warranted for 1 year. That year is not yet up, Your Honor. I have had an estimate done of what it will take to remediate the items in my kitchen that are substandard, do not pass inspection, and I have requested be fixed by Mr. Guadron. He has refused communication. He has done shoddy repair work. Behind me are 2 full tiles of flooring that were available to properly repair the floor. Instead, he put in a little plug in the flooring that has a hole all the way around it, and in the center, they go straight through the subfloor and into the insulation. In the picture showing that, there are numbers 1 and 2. 1 shows the pipes passing from under the cabinet and into the floor. Plumbing regulations require that something like this item, I believe it's called an escutcheon, this one was made in 1914, go around those pipes and secure them to the floor. This prevents my plumbing from passing inspection, an inspection for which a permit was never obtained. If Mr. Guadron is a plumber and a plumbing contractor, he ought to have gotten the proper permit to do the plumbing work. He did not acquire that permit. I do not know if he got permits for remodeling. I have not checked. I never saw one. The only permit I ever saw was for electrical, and I paid for that. If you notice in the picture where the floor has been repaired, you will also see at the back of the wall, there are no baseboards. This means should any pipe burst, should there be any kind of leak whatsoever, that water is going to go down there at the base of the floor, ruining not only the sheetrock behind it, but possibly the underlying subfloor, the insulation, and even the foundation. It can contribute to rot and mold. In addition, insects can come up through there. Food items can get trapped in there, so it creates a very unsanitary condition. This ought to have been fixed. My requests have basically been